This is American Government on Wednesday, November 18th. This is my last recorded lecture for the course. And I just want to pick up um, on the connection that I made at the beginning of Monday's lecture in introducing Chapter 4 in the Wilson text on civil liberties. This is Chapter 5 on civil rights. But just to remind you that the reason I placed these materials, which after all are chapters 4 and 5, would seem to come between after chapters 3 and before chapters 6. See what a PhD will get you. Anyway, the reason I put them at the end of the course here is because they raise some fundamental questions about the regime. Interesting considerations that form, I think, an appropriate closing parenthesis to the reflection of the opening and closing of the course and my design of the course. But remember, it's because I argued that these subject materials are essentially the development of doctrines formulated on the Supreme Court, and that in some ways, as we saw in Chapter 4, some of the divisions between judicial philosophy, or the controversy over judicial philosophy, originalism versus living constitution, or activism, or restraint versus activism, play out in all of these areas of personal liberties, as the court developed different theories that extended and expanded the reach of the Bill of Rights and applied them to the states. But then in some ways on the question of equality. You could say in some ways we come back to the Declaration of Independence. The Declaration of Independence tells us that human life is about liberty and equality. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, among which are life, liberty, and the pursuit of happiness, and to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, and it becomes the right of the governed to alter or abolish constitutions when they fail to attain the end of securing liberty. So, or equality for that matter. So, the theme of liberty and equality hangs over American life like a presiding eminence, because it is the presiding eminence of American life. American life is a debate about how to be free and how to be equal. And in some ways, Chapter 4 deals with the personal liberty expansion of this, and Chapter 5 deals with an attempt to generate or to give more effect to the Declaration's embrace of human equality within the structures of the Constitution. And so, just to remind you that the useful distinction between civil rights and liberties, which is in a way, I think, shaping up to be the tension between liberty in the regime and equality, is on page 57 of Chapter 4. Put my additional eyes on for those of you who are younger than 68. On page 57, civil liberties are the rights, chiefly rights to be free of government influence, that accrue to an individual by the Constitution, free exercise of religion, speech, and so forth. Civil rights, to be discussed in the next chapter, usually refer to protecting certain groups from discrimination based on characteristics such as sex, or sexual orientation, race, or ethnicity. Equality. And this from page 78 in Chapter 5. Civil rights cases refer to cases in which some group, defined usually along racial or ethnic lines or sexual or gender lines, is denied access to facilities, opportunities, or services that are available to other groups. The pertinent question regarding civil rights is not whether the government has the authority to treat people differently, it's whether such differences in treatment are reasonable. But in other words, obviously treating people equally in some ways, well, this is the question with inequality. We see this in feminism. There are different strands of feminism. Does equality meaning treating people the same or different? So, as we'll see, that relationship between sameness and difference is at the heart of different understandings of civil rights in American history. So, the main questions I'm going to deal with in our discussion of Chapter 5 is race, and primarily, I guess you could say, in its Plessy and in its Brown phases. Plessy v. Ferguson in 1896, we'll get back to that. And then, which you could say that era is ended with Brown v. Board of Education. And that leads to the last two major considerations in this chapter, which is, okay, so as you're going to see, Plessy said you could take people's racial differences into account and other kinds of differences, and as long as you treat them equally, you can treat them differently. And Brown seems to, in 1952-54, Brown v. Board of Education, while it didn't fully overturn Plessy, it limited its scope, especially when it came to public education, that to treat people differently would be to treat them unequally. And that leads to, again, the two major last considerations, which, well, okay, if you treat people differently, are you treating them unequally? And it leads to, this is well described, I think, in the Wilson text, the tension between equality of opportunity and the quality of results. And that will bring us back to a concluding reflection for the course and, as you'll see, point to Harrison Bergeron. So let's talk about race and equality. And although we're talking about race, you could say that these issues frame all discussion of equality, and that's why the equality of opportunity and equality of results discussion in Chapter 5 is an important, it's a necessary outcome of the issues of equality and race, but they cover equality on all different dimensions throughout our society. So obviously, the constitutional background for this is the 13th, 14th, and 15th Amendments. When people talk about systemic racism in the United States, clearly you have to talk about, well, what's the political system? And we've talked about that from the beginning of the course. And you'd have to say that both in law and institutional structure, inequality was present in our original constitutional system because of the Constitution's openness for the purpose of getting the revolution going and for getting the Union set up. It made its peace with slavery in Article 1, Section 2, Article 1, Section 9, and Article 4, Section 2. But that, you could say, the first giant regime change in that respect was the 13th Amendment. And the background for the 13th, 14th, and 15th Amendments that I want to use as the background to discuss Plessy and Brown, etc., and the whole question of equal jurisprudence, equality jurisprudence, is the discussion from Monday's class on the distinction between the three kinds of rights that are relevant in our system of government and politics: natural rights, civil rights, and political rights. And if you remember, just to remind you, the largest sphere, which encompasses all humanity, are natural rights. All human beings have natural rights because those rights are constructed in their natures, according to the Declaration. Once civil society exists and government exists, then the way our natural rights are protected within the structure of civil society is civil rights, like the right to a trial, the right to a jury, the right to protected press and free speech, the security of property in your houses in the Fourth Amendment, and all those kinds of things. Those are civil rights, which are the freedoms and liberties guaranteed within society and under government that are the reminiscent or the civil echoes of our natural rights. And then, of course, political rights, the right to be an active participant in the political system, are the smallest of all, because, again, by the Constitution, it only includes all adults over the age of 18. So children are citizens and have civil rights, but they don't have political rights. And obviously the amendments, like the 15th Amendment that dismantled race, is so to set this thing up. The political system includes core principles, as we've already seen, and then institution and laws, and then the citizen way of life. And that you'd have to say that in some ways, the 13th, 14th, and 15th Amendments were an attempt to take that framework of three kinds of rights and desystematize the discriminations based on race that existed radically under slavery, which deprived black people of their natural rights. And then once the 13th Amendment was passed and that abolished all aspects of slavery within the Constitution, as I mentioned on Monday, the problem is after the 13th Amendment was passed in 1865 and the Civil War was over and Reconstruction began, then many of the pre-Confederate states of America that had been the Confederacy immediately damaged the civil rights, the equal civil rights of their freed African-American slaves, who were, after all, now citizens. But the whole point of the black codes that I talked about was to discriminate with respect to civil rights. And the 14th Amendment then says states can't do that. They have to treat people basically the same. And the federal government will make sure that that happens, and has made sure that that happens. In this chapter, by the way, the Civil Rights Act of 1964-67, the major civil rights legislation, that was an attempt to use the power of laws to remove the civil discriminations that were the after effect of slavery. And then the 15th Amendment, of course, was in response to the attempt primarily of Southern pre-Confederate states, Confederacy states, using both legal means and state organized pressure to prevent African Americans from voting. So natural 13th Amendment rights, 14th Amendment civil rights, and 15th Amendment political rights. So especially with respect to equality, we're talking now in the first clause of the 14th Amendment. All persons born or naturalized and subject to the jurisdiction thereof of the United States are citizens of the United States and of the state wherein they reside. No state shall abridge or deny the privileges and immunities of a citizen of the United States, nor deprive any person of life, liberty, and property without due process of law, nor deny to any person within their jurisdiction the equal protection of the laws. We're talking mostly in this chapter now about the Equal Protection Clause. Now, to some degree, and this is still a great debate in our system, the Supreme Court in 1896, in giving official interpretation to the Equal Protection Clause, had to do with an Louisiana statute that denied blacks and whites the freedom to sit with each other on trains. Plessy, by the way, was, I think, 1/16 black, which was how the Louisiana law described it. He actually looked more Caucasian, and that's how he got to. But then he revealed that he was actually 1/16 black, and they put him in the caboose, and because black and so forth. So on one level, there are actually two opinions in Plessy v. Ferguson. The majority opinion of Brown, which gets complicated because the case where the Supreme Court modifies the rule out of Plessy is Brown v. Board of Education. Couldn't his name have been Bubba? Anyway, there are two opinions of note in Brown v. Plessy v. Ferguson. One was the majority opinion, and that, of course, creates the famous term separate but equal. You can have separate racial facilities for blacks and whites as long as they are equal. And now, of course, that abstracts the fact that so the way that Brown, not Chief Justice, but Brown characterizes the issue of Louisiana's statute forbidding blacks and whites to sit together is that it falls equally on blacks and whites, and it prevents white people from sitting with black people and black people from sitting with white people. Now, of course, it completely ignores or abstracts from the fact that whether or not the equal facilities are in fact equal. And one of the things the Supreme Court did for the next several decades to keep this precedent, because it respected the precedent of Plessy v. Ferguson, was to insist that separate facilities actually were more and more equal. They actually compelled the state of Texas to build an exact parallel, which the state of Texas was so willing to hold on to segregated schools, law schools, that it did that, or at least tried to do that. So, by the way, the other interesting constitutional opinion in Plessy v. Ferguson is Harlan's dissenting opinion that the Constitution is colorblind, and that the problem is the 14th Amendment means you can't distinguish people into racial groups at all. That any racial distinction is in fact a form of inequality, and therefore the only proper constitutional policy is colorblindness. That opinion resurfaces, as you'll see, in contemporary life over the equality of opportunity and equality of results, especially in the controversy over affirmative action. So, at any rate, that jurisprudence dominated at least racial legislation in the United States. So you could say there was still a systemic racism, in the sense that even though the 13th Amendment got rid of the systemic racism within the Constitution of depriving depriving African Americans of their natural rights. And even though the 14th Amendment put certain restrictions on states discriminating against their own citizens based on race, in some ways, by permitting racial classification, the Supreme Court did allow a certain kind of systemic racism to persist, and that was in desegregation and what generally came to be called Jim Crow laws, the legislation in the last part of the 19th century and the beginning of the 20th century. So in Brown v. Board of Education, first argued in 52 and I think decided in 1954, the court unanimously didn't simply overturn Plessy, but they decided not to apply it, first of all, to public education. And it has become, you could say, broadly speaking, Brown is understood to, and even if it doesn't fully and completely, it nevertheless overturns Plessy in that it says it's not applicable to public schools. And that's literally the holding, that to separate black children out from white children actually puts a stigma of inferiority on black children. And even though it appears on the surface to be separate but equal, simply the separation itself is a badge of inequality. And so the court overturned that, and of course that defines part of the struggles between the national government and the states and local governments, don't forget, the tension between the national government and the states is also one of the major themes in American politics too. Here in this area, it turns out this was the resort to state power was to resist the calls on the national government by the civil rights legislation of Congress and by the Supreme Court jurisdiction. It was an attempt on the part of states and localities to resist desegregation. So you could say this: no matter what side of history you are, sometimes it looks like the conservative right that appeals to state rights. Sometimes it looks like it's the radical left in the form of sanctuary cities and etc. and drug laws that appeal to the left. So the decision between national and state, the distinction between national and state governmental power is still a pretty critical one within our system. And in this case, at this time, it enabled those who resisted national desegregation to resort to state and local authority. But now it's the shoes on other feet. So anyway, you could say that what happens here is the question the Supreme Court raises by Brown, and this becomes implicit in subsequent court cases that ordered busing, is that the court ordered states to stop segregating. So what Brown v. Board of Education was about was desegregation, breaking down the legal categories. But of course, the problem is nevertheless that within public schools that remained racially imbalanced because either white parents took their children out of the public school system or moved outside the city, the Supreme Court began to shift towards using federal judicial power not just to desegregate existing facilities, it was called de jure, by law segregation, but to use positive judicial power to actually force blending, which is integration, when it became clear that simply desegregation wouldn't lead to an amalgamation of the races, that in some ways the blended race society that is kind of at the base of Brown v. Board of Education, and I think actually tends to support embody what most Americans imagine as the proper outcome of racial distinctions in civil rights in America, which is a racially blended society. And so that's been the issue, and of course that leads to the last two major considerations in this class. I'm not going to specifically go over them for gender and sexual orientation, but the discussion that is worth bringing to your attention is what the Supreme Court essentially has done when it comes to classifying people by gender, by race, by gender, or sexual orientation, which of course first in 2003 the Supreme Court decriminalized all state laws that criminalized homosexual behavior. In 2015, as you know, in Obergefell v. Hodge, it legitimated same-sex marriage as a form of equality under the 14th Amendment. So you have to say that the interesting thing here is so the Supreme Court understands equality. Still, in certain areas, you can actually make distinctions between people, like men's and women's restrooms, although that's difficult with the transgender movement rising. But nevertheless, most Americans don't see as a form of invidious discrimination classifying people into men and women for purposes of privacy and restrooms and all women's colleges and so forth. So in some ways, what the Supreme Court seems to be suggesting is you can classify people by race or gender or when there's a reason for it, when there's a rationale but the disposition is that most classifications are suspect. That if you're classifying people, you're probably doing it for invidious or discriminatory reasons to actually oppress a minority or something like that. And so, in some ways, that's where we are. Is the Supreme Court will allow states and even the federal government to classify people. After all, affirmative action programs and diversity programs require you to actually pay attention to race. So the court has allowed some racial classifications, although treats and gender, etc., mostly as suspect. But if there's a compelling state reason for the state to use its police power to regulate the health and morals of society, it will allow some distinctions. And so that leads us to the last major conceptual issue raised in Chapter 5, and that's equality of opportunity versus equality of rights. And let me tie that question into a conclusion of the course for you to think about. And this has to do with the entire American regime. We have seen that the core American principles in our regime, the core of American principles, is the idea of natural rights in the Declaration. And that this concept weaves together two subsidiary concepts, that human beings are by nature free and equal. Are the two parts of rights, equality and freedom, freedom and equality, liberty and equality, identical or so easily harmonized? Harrison Bergeron by Kurt Vonnegut suggests that these two concepts are not, in fact, the same thing and may even, when pushed to radical extremes, undermine each other. As President Obama suggested, our political future consists in our finding new meanings and applications of our core principles in the Declaration to ongoing and unavoidable problems in each generation. In general, I would say, now that I've walked you through an entire semester of examining the structures and ideas in American government and processes of governing, that our decent political future may depend upon maintaining the core constitutional arrangements of the founding, the separation of powers, checks and balances, federalism, improving them by bringing them closer to the ideal of the Declaration, which they clearly have been, and modified by attention to the needs of the present and the challenges of remaining a global leader. That, I suggest, is what the task of your generation and the upcoming generations of American life is.